Good evening, everybody. Welcome to another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, back for another week with my co-host, Julio Vela. What's up, man?
All right.
You've been watching the Olympics?
It's the mechanism.
I know, but you've seen them all over the Olympics, right?
Oh, yes, yeah, everywhere.
Oh, yeah.
And I've seen all the Longhorns on the Olympics.
That's right.
Yeah.
We're getting ready.
We've been ready.
Yeah.
Brad, where'd you go to school?
UH.
Hey, eat 'em up. Go Cougs.
Go Cougs.
Whose house?
You didn't
It's
even
Cook's
introduce
house.
him before you brought him in.
It's everybody. Go for it.
Our guest this evening, prematurely brought in by my co-host there, Brad Walters. Brad, nice to have you on the program.
Well,
Good to finally meet you, too.
Thanks for having me.
Absolutely.
Been looking forward to being on the show.
Yeah, well, I've seen your name all over a lot of places, so it's good to finally meet you in person and have you on the program.
Thanks.
We got a great show tonight, ladies and gentlemen. Got a lot of great topics to get to. For a change, not a lot of stuff emanating out of Harris County this week. Few things, but not too much, which has been a change from our last couple shows, Julio, where we've just had story after story coming out of Harris County. But we're going to have a great time for the next hour talking with Brad. We'll also open up the phone line starting around 8:30 for your questions and comments. You can call us, 713-807-1794. We also have Twitter up. I'll be taking your questions and comments on our Twitter feed at HCCLA_TV. So, like I said, guys, we didn't have a whole lot going on out of Harris County this week, but we had a whole lot going on up in Waco. The biker case, of course, has been going on. You know, Brad, you and I were talking before the air. This case has been going on for a long time now, and we're just now getting to a hearing to disqualify the DA himself, Abel Reyna. We finally got the evidentiary hearing. As some of you may recall, we had Abigail Anastasio on, what, about a month ago, Julio?
About a month.
Something like that. And it was, I guess, right after the initial hearing had been passed, got reset to this date. And so they finally had the evidentiary hearing. Very, very interesting evidentiary hearing. A lot of conflicting testimony about what happened. And of course, for those of you who haven't been following closely or haven't been watching this show, shame on you. The crux of the disqualification is that Abel Reyna and his DA office went out to the scene and basically took over the investigation and from law enforcement. And they started directing law enforcement on what to do, how to do it. And the big thing to me that came out of this hearing, and I'd like to get you guys' opinion on the whole thing, but the really big thing that came out to me was that his office sat there and drafted the probable cause affidavits. And we talked ad nauseum about those affidavits. They drafted them. These cops signed them, attesting to personal knowledge of the facts therein. And what came out in the hearing was they had absolutely no clue about the facts that they were attesting to. Just amazing stuff, really.
So what's the problem? What's the problem with that? DA writes an affidavit, cop signs off on it. No big deal, no harm, no foul.
He had no personal knowledge of any of that stuff. It was so absurd. In fact, if you read the affidavit itself, he doesn't even say that he has knowledge of those facts. He just says that he believes these because, and then there's a list of things that he doesn't even say how he knows any of it.
And we just recently, maybe within the last 6 months, an officer in Houston got in trouble for swearing to affidavits that he either falsified or had no knowledge to about stopping individuals for DWIs and such. And so the idea is that the district attorney was it wasn't the district attorney that was just writing these affidavits, these warrants.
It was unclear to me, and if anybody, if Abigail or any of the other lawyers who were involved in this were present at the hearing and know more, all I have is basically the news articles. I didn't attend the hearing. I don't know if the DA himself, Abel Reyna, actually authored it, or if his underlings were authoring the affidavits. I would imagine that it's a group effort, given the number of affidavits that were done. I can't imagine. The DA himself sitting down there with the laptop and, typing out each affidavit on the scene. But I'm sure it was a collective effort to get 100 and whatever affidavits done.
In the discussion from the article that I read, the DA's claimed that they got the information and facts that they put on there from a variety of different officers, but they didn't name any of them.
Nope.
And Chavez never attested to any officer that he talked to verify any of those facts. And he, in fact, never even said in the affidavit that he had personal knowledge of any of it. So I don't see how on its face any of those affidavits could keep anybody on bond for anything. You know, the case should be over at this point, and they should be starting over from scratch.
You say that, but I mean, so obviously this was a motion to disqualify the DA's office, and really it comes down to whether or not there's a conflict, and there's some other stuff that I want to get to on that. But touching on your point, Brad, okay, so people are going to say, well, hell, they had bad probable cause affidavits. You say the case should have been over. Now they got indictments. I mean, what can you move to quash those indictments at this point? I mean, what's the remedy at this point?
You know, you don't ever have much success with quashing indictments. I mean, you almost have to you have to get the record and show that something false was shown to the grand jury to get that indictment. I don't know if it would be enough to show that you gave them something that just wasn't sufficient.
So there's this,
Yeah.
these affidavits that officers are swearing to. What's the purpose of these affidavits, and why do we even need these affidavits for what?
Well, you need a basis for the warrant to begin with, and so a warrant shouldn't even issue. And then, if there is a problem with that affidavit, then the warrant should be quashed. It should be gone.
From what I understand and how it played out is the district attorney got on the stand and said, you, to the chief of police or to the police agencies, you better read this affidavit line by line because you're going to have to swear to it. And then Abigail asked, or the other attorney asked, so if we were to bring the officer on the stand who swore to it, he's going to testify that you had this conversation with him. So when they brought the officer on the stand to say, did you have this conversation with the district attorney that you verified all of these facts and that you swore to it, and you sat down with him and you had a conversation with the district attorney about these facts, is that true? Apparently that officer said, no, I never had a conversation with the district attorney, and I never sat down with him to discuss these facts.
He indicated that he trusted what other officers had told them about the investigation, but he really didn't know anything. He just didn't have the goods, and his name's on the affidavit. So, you know, I mean, I know that the hearing was about something else, but it just becomes so flagrantly obvious that affidavit is worthless. All of those affidavits are worthless because they're cookie cutter affidavits. They're all the same.
And we call that, Mr. District Attorney of Waco, perjury. Just calling it out there. Just throwing it out there. That is lying on the stand, and I'm excited to see and enthusiastic to see what's going to happen on it. I mean, what's the next step? And I think you're going to talk about some conflict that might be involved.
Well, so they've got a bunch of civil rights lawsuits pending. You know, a number of bikers have filed civil rights lawsuits in federal court, and they've landed in front of Sam Sparks, who took over for Walter Smith. For those who don't know, Walter Smith, the federal judge in Waco, has been, let's say, relieved of duty. He made some disparaging remarks about another judge in the Western District of Texas, so he's been relieved for a while. And so Sam Sparks, who is he does not suffer a fool lightly, let's put it that way. And he had a hearing earlier this week or late last week. My days are all running together, but the bottom line is at that hearing, he suggested we seem to have a little problem here, and I think Mr. Reyna may have a problem here because you know he's still continuing to prosecute, but he's got some financial interest at stake in this thing.
Why?
Well, because he's been sued personally in the civil rights lawsuit, and the question now is, by his actions, has he lost his prosecutorial immunity by stepping in and doing what he did? And you know, has he lost his under the law? There's he has immunity for his acts as a prosecutor. The question is, does his acts of what he did in this case, does that not fall under the umbrella of being a prosecutor? I think it might, very, very strongly. And I think Judge Sparks has some real questions about that. And so he suggested there may be a real issue here.
Yeah, I mean, from what I understand, he originally, when he showed up on the scene, they were just going to interview, identify people that had information, and release them.
Right.
And he shows up and says, "Oh no, we're arresting all these people as a criminal enterprise."
Yeah.
And that's where, he decided to make the arrests. He made the arrest decisions, and that, it's one thing to say I'll accept charges. It's another thing to say, no, arrest all of these guys.
So tell me how that differs, though, and how he's not able to continue to prosecute. Because sometimes in the movies we see them calling up the U.S. attorney or the attorney involved with the government, and that attorney is leading the sting, or that government attorney is leading the prosecution. Like today, there was 6 or 7 arrests for the Kush. Right, and Devin Anderson came out, and as she has with Kush and prostitution and other things, saying that, we're leading this charge and we're going to go after these individuals. How is that different than from what the district attorney did down in Waco? I mean, is it the hands-on involvement? Is it the making the decisions? How is that any different, though?
I think she may be stepping out also. I don't know that it's different. She may be stepping out of her role also, and if they bring some bad charges, she may have exposed herself.
Well, I don't see her going out to the scene. I think that's the difference here. What I do question, though, and I've always questioned for a long time, is the DA's office here does have that vehicular crime section. The Harris County DA's office does have a vehicular crime section to combat intox manslaughter cases, which unfortunately are prevalent in this county. But a lot of the prosecutors in that section will make the scene of those cases. And this, this case kind of opened up some questions for me about what really goes on there in the intox manslaughter cases, because I think it's kind of standard protocol that if a DA is available in the vehicular crime section, they go ahead and make the scene.
Well, and then
so I don't really know. I mean, that comes closer perhaps to the Waco situation than I think the Kush situation does, because I don't see Devin giving a press conference about the arrest or about the temporary restraining order that she did to tell these guys basically shut it down or we're going to come after you type thing. I don't see that so much. I know we've had a lot of talk about restraining orders, but I don't know that rises to the level of what happened in Waco in terms of them actually making the scene and directing an investigation.
Well, and from what I understand in Waco, there was some discussion, from what I understand, that he's going to be covered up to $500,000, and then anything more than that, he might be individually liable for. Apparently, they put his lawyer, and he said at one point, and he said, "Well, my lawyer's here. Why don't you ask my lawyer?" And then they put his lawyer on the stand to talk about what he's going to be liable for, what his insurance is up to, and such. And I don't know. And and there's some real good stuff about some background stuff.
That would make me feel real good
it.
if I was a taxpayer in McLennan County.
Well, and that's what he said. Apparently he said, "I'm not on the hook for it, for the millions of dollars that they're suing me for. The taxpayers are on the hook for it."
Yeah.
Ooh. Apparently, that's what he said. I don't know. We'll get the transcript or something, but that's what I understand.
What this case highlights to me is the problem on the front end of so many of these cases. Where we come in with a broad brush, we just pick up all these people. And in a small county like McLennan County, which is a growing county, it's not like going out to Palo Pinto County or something like that. I mean, it's a pretty good sized county, but it doesn't have the resources of Harris County or Travis County or Bexar County or Dallas or Tarrant County. Probably didn't even have the resources of Fort Bend County or even Montgomery County. But nonetheless, the troubling thing to me is just this broad brush that they used to sweep everybody up under what clearly is false affidavits, perjured affidavits, if you want to call them that, but they're certainly false, and yet all these people were held and put on $1 million bond to start.
Outrageous.
And there's no remedy for it. That's the problem, is that now we've got to the point, those people sat in jail for all that time on $1 million bond. Not only could they not make a bond, but they couldn't get a bond hearing in any kind of reasonable amount of time, majority of them. And now there's no remedy for them.
Some of those guys got their motorcycles confiscated.
Yeah.
They just snatched them.
Yeah.
They're ours. It's the state's now. It's ridiculous.
From what I understand, and going back on what you had mentioned, that the police agency initially was, we're not going to arrest all these people. There's no reason to arrest all these people. But it was Mr. Reyna, it was the district attorney that said, no, arrest all of them, put them in, lock them up. We're going to task on this.
And that's the crux of the whole argument as far as him stepping out of his role. So, he might be in trouble.
Apparently, from what I understand, his dad was some sort of judge, and he was.
They're a very old school. Dad was, I think, a district court judge. They're a very well-connected political and legal family in McLennan County.
Apparently, the judge that's hearing the case is Mr. Reyna's old law partner too. But apparently, from what I understand, he's been fair and impartial and been a good judge so far. But man, can you imagine going into the wolves' den, where the guy you're going after, his former law partner, is a judge?
And that's why I'm not sure. Although I think there's probably a very valid basis to disqualify him, I'm not sure that this judge is going to do it.
Well, but from what I understand is how he's been going is, that's on the table, obviously, but he's been okay so far. I don't know.
I guess it remains to be seen.
I don't know.
It remains to be seen. We will continue to watch, of course. Next thing I want to talk about, guys, is the DOJ findings came out this week about the Baltimore Police Department. And wow. All I can say is wow, because that report is unbelievable. Of course, in the wake of Freddie Gray and some other incidents in Baltimore, DOJ came in and did an investigation of misconduct and mistreatment on the part of the police department, much like the DOJ did of the Harris County Jail here, and released a report and findings. What struck me about this, guys, though, is the DOJ actually conducted and went on ride-alongs with the police department. And it didn't faze these cops at all. That you have monitors from the DOJ sitting in the squad car with them to see what's going on and to make a report about misconduct, and they're committing misconduct in front of them. That was the most amazing thing of all to me.
Old habits are hard to break.
It is amazing, man.
I was just stunned. There were incidents where they were, strip searching people, doing anal cavity searches right in front of the DOJ monitors. It's like
This is okay.
What is going on here?
And I think, before the patrol, they're all putting their hands in and saying, go arrest everybody in the hoodies. What's going on here?
Yeah. Let's clear corners. What was it? One, they said, let me find it here. I think it was one of the cops said, well, we don't have any basis to do anything to him. And the other guy, with the monitor right there in the car, says, well, find some, make some up.
Yeah. There's talking about those anal cavity searches for drugs and that kind of thing. I mean, there's been 2 or 3 of those here in Texas. Same type situation. So don't think this is just a Baltimore thing. I mean, this is everywhere. It's amazing how people are just so unaware of how bad a lot of these law enforcement people are and how ignorant they are of just simple things like the Fourth Amendment. They just have no idea what they can do on a search and seizure situation, and they just do what they want to do because they've never had problems with it before.
Well, and it goes, I can't help but think about, you see all these things on social media or the TV that says, hey, look, when the cop says, put your hands on the wheel, put your hands on the wheel and don't talk back and nothing will happen to you and you won't get shot. Okay, so maybe you do that. Okay, fine. A cop pulls you over. You don't, even though you're not doing anything wrong and you don't object to him and you put your hands on the steering wheel and you just be a good citizen like you're supposed to be. But then what happens when they anal search you? Like, then, are you just supposed to be a good citizen at that point and, let it happen? It's Brad, let me ask you, do you think that DOJ finding of the police action is something that's limited to maybe the northern states, or is that something that, if they did it everywhere else, they'd find it? Or what do you think?
It's widespread. Like I said, there have been in the news at least 3 cases just like that here in Texas. And yeah, the officers did end up getting fired, at least the 2 oldest ones did. And I think this most recent one, it's still in progress. But it's just amazing as much as those first couple of cases got publicity that this most recent one has occurred. It's like what's going on in these guys' heads that they don't even know what's going on with their fellow officers and people doing the same type of work, that they can't just do this kind of thing to people.
What do you think's the remedy? What do you think can help that? What do you think?
I don't know. The big takeaways from this, to me, the big headlines are that they find that the Baltimore police performed unconstitutional stops, frisks, and arrests, and that they disproportionately targeted black residents. That they held. This is just the highlights, but it's so held an us versus them mentality. They said that the officers retaliated against citizens, took a lax approach to sexual assault cases, employed excessive force too freely, and used slurs against gay and lesbian people. That's stuff like that. I don't know that there is a solution for, because you're not going to be able to legislate using racial slurs or slurs against gay and lesbians. You can't fix that. You just can't. I don't know how. What do you do in an interview of a police officer? Hey, do you hate black people? Do you hate gay and lesbian people? Do you do a F. Lee Bailey, Mark Furman cross-examination style? Have you ever used the N-word?
Yeah.
Do you do that? I don't know that you can. So from that standpoint, I don't know that you can fix that. That's, to me, and I hate to say it and sound like, just somebody who is just like, hey, we can't do it, but I don't know how you fix that, because that's just that's a human fault.
It's a hiring issue.
Yeah.
They can do polygraphs. They can do a lot of psychological testing that they're not doing on these people. They're going through 6 months of training and giving them guns and badges and putting them out there to do whatever they want to do, and they don't know that much about them. Or a lot of times they do know stuff about them. A lot of times they're coming from other agencies, fired, and they put them right back out there.
That's right.
But I do think that in terms of unconstitutional stops, frisks, and arrests, okay, that's something where you do have some control, I think, because you can, especially now in the days of body cams, you can look at what they're doing. And if somebody performs an unconstitutional stop, you want to talk about the DA's office getting involved with police, have them come over and teach a search and seizure class. Come over and teach, how to properly stop someone, kind of thing, that doesn't violate the law. I'm not sure how that would go over. Of course, we'd object and say, what's the DA's office doing? Go and teach the police. But get some lawyer, hire somebody, hire a lawyer to come in and teach Constitutional Law 101 at the police department. And if you see a violation, you put it in their file and you can suspend them without pay, and once the violations rack up, they're gone.
Well, I don't know how much progress I make dealing with these things on an individual basis myself, but when I have an officer that has violated my client's Fourth Amendment rights during a stop, I get on the phone and I get hold of his sergeant and I say, you need to take a look at this guy's video on this stop. He did not have didn't even ask for consent. He's putting his hands down the guy's pants, in his pockets, and all that's supposed to be occurring at this point is possibly, if he had some reason to think he might be armed, a pat down would be all that would be called for at that point. And so I'm having these guys look at the videos, calling and getting hold of the internal affairs guy and say, hey, look at it. And I had a Laporte case. I won't name the officer right now, but I had 2 cases that ended up getting dismissed over that kind of thing. And he said, well, thank you for letting me know this. And he said, I'll give you some feedback after I've seen the videos. And he said, well, we've given him some education on it. He didn't say discipline or anything like that. But the cases got dismissed, and DAs wrote on the file, C states file. They wouldn't really give us a reason.
Of course.
Okay. But then I had a felony case come up involving that same officer that I had called in on. And I asked for those files because it was another situation with a bad stop, bad search. And I wanted those files to prove this guy had a pattern, a pattern of doing this. And our guy, you said, you like this guy, Nick Socius was the DA that I was asking for the files from. He emails me and said, we've located the files. And well, we'll turn them over to you, but I just need you to sign that you won't use these for anything else other than the case at hand. He didn't want me sharing them with all of y'all.
Right, the protective order.
Really what he should have been doing, he should have been getting this guy Brady listed and never able to take the stand again, is what he should have been doing. But no, he tries to keep me from letting other people know what this guy is doing. And I said, no, I'm not signing squat. And he would not turn those files over. And they were definitely beneficial and helpful to my case, material to this guy's history and pattern of doing things. And he just would not turn them over. And that case ended up getting dismissed as well, rather than turn the information over to me to use.
I just don't know too many other jobs where if you didn't follow the handbook, and I would kind of think that as a police officer, the Constitution's kind of the ultimate handbook. that if you don't follow that, if you don't follow the handbook, you're out. I mean, what? I mean, look, did you guys? I know you're a football fan, but are you a football fan?
I haven't been keeping up with it as much as I used to.
Shame
I
on you.
like the Texans though.
This is a football set right here. Hard Knocks. Did you watch Hard Knocks?
Yeah.
Okay.
Saw that?
Yeah.
So this year, they're doing the Los Angeles Rams. Okay. Well, the Rams have a policy that you don't bring girls into the dorm room at training camp.
Gone.
Wide receiver brings a girl into the dorm room, not to have sex, not to hook up. She's just there dropping off a package and she's gone. But she was in the dorm room, and Jeff Fisher said, you know what? You're out. You're out. We got rules. You don't follow them, I'm cutting you. You're done. You know? I mean, like, it's not that hard.
And that's not a certain inalienable rule.
Right.
Right? I mean, like the Constitution would be. Those are things that I agree with you. There's certain rules. And you know what? I'm getting sick and tired of hearing the DA office wanting to keep contained bad officers. Mm-hmm. I mean, how are you or another defense attorney supposed to consult with another defense attorney regarding strategy, regarding just questions on how to proceed when there's a protective order in place?
Well, but you say that, okay? And I hear what you guys are saying about making the Brady list and doing everything. To some extent, we shouldn't expect them to do that job. We shouldn't. I mean, I know theoretically we should. Yeah. But
their first job is to do justice, not seek convictions, and they're not even trying. They're not even trying when they're not trying. When they're allowing these people that they're known liars to get on the stand and continue in future cases.
But their job is also not to help create the database for defense attorneys to cross-examine witnesses. I mean, frankly, we need to do a better job of doing Public Information Act requests. I mean, that's what it comes down to, because nobody can tell us what we can and can't share Public Information Act requests. So, I mean, to some degree, I can understand if you are getting a background or a file as part of a litigation. Frankly, I understand the outrage from our side of the bar about why are you trying to get a protective order and hide that. But if you walked across the street to the civil courthouse and somebody got a file or something, an internal file from a corporation or anything like that, it'd be subject to a protective order, and they'd say you can't use this for any purpose other than the litigation at hand. So from a legal standpoint, I honestly don't have a problem with that, from that conduct. I mean, I know that we think they should be seeking justice and doing the right thing, and that means sharing the information. But from looking at it in a court point of view, I honestly don't have a legal problem with that. I think they're on solid ground legally with that. I think it's just, as a defense bar, we got to do a better job of really pushing the Public Information Act requests. And I wonder, because you guys, there's been talk about setting up a better civil rights bar in this city. There's been some chatter about that, and I think that could help. Mm-hmm. That could really help to bring some of this stuff to the forefront. It really could. Some
of the things that I have found when I request the Public Information Act is that I won't get the unsustained findings, in other words, just the allegations that weren't or that did not end up in a sustained finding of misconduct. I also won't get the pending actions against individuals, which, as we know, if an officer is under investigation, it could take months, it could take years before it's closed. And in between the start and the finish of that particular officer's internal affairs investigation, I could have 1, 2, 3, or 4 cases in the interim that I might not get a hold of. Now, I think the Public Information Act request should guarantee me to get those things.
Sure.
But I don't necessarily know if who's handing them over is actually doing all that they should. I don't know.
I don't either.
I'd like to get all the unsustained findings.
We've reached the 8:30 part of this show, halfway through. We're going to open up our phone lines right now. 713-807-1794 is the number. Please call in with your questions and comments from me, Julio, and our guest tonight, Brad Walters. Also, reminder, we do have Twitter up at HCCLA_TV, so you can shoot us your questions and comments there as well. Interesting article in the New York Times over the weekend, and that was this notion of the vanishing criminal jury trial, at least as to federal court. It focused on the Southern District of New York. I mean, I think we know here that in state court we are not lacking for jury trials, so to speak. We got more than enough. I think you've heard the statistics. There are at least 2,500 to 3,000 cases set for trial at any given time in the Harris County courthouse. So there's a little bit of a difference here, but the New York Times had this kind of op-ed about how jury trials are vanishing and is justice really being served behind closed doors, and it focused on what's happening in the Southern District of New York in federal court and how plea bargaining has overtaken the federal criminal justice system and leaving very few criminal trials. I don't necessarily find that to be the case. I have a very heavy federal docket. I do more federal court than I do state court. So I read this and do more of my cases resolve in pleas than in trials? Yes, but I think that's everybody in criminal cases, isn't it?
True.
I mean, so this whole notion that we're losing the jury trial, I think is a falsity to some degree, because there still are jury trials out there. But I do think that our punishment system is out of whack, and that's what's causing it. I think that, and looking at both, I mean, the federal system is so far out of whack that, yeah, I think the trials there have dropped off enormously from what you used to have. But I do think that also in state court, trials have dropped off dramatically from what they once were because of the trial tax. We all know it. Mm-hmm. We all know about the trial tax. That if you go to trial, you're going to get a worse punishment than what the state's offering you. Mm-hmm. Happens every day around here.
I had a case. Of course, I don't do anything in federal court, but I had a similar situation. I was worried about the trial tax. Mm-hmm. And I really wanted to go forward with the case because there was some misconduct involved with a couple of the police officers in the case. And that's what really makes me want to try a case, because I want that judge and I want those DAs to know what these guys did. And that's my 2 cents on how I feel like I'm contributing to the system. But I also told the judge, after explaining, whether we were going to go forward on this or not, I said, by the same token, I don't want to force my client into something because I want to get these guys. And she had suggested maybe the DA could offer this or could offer that. And I said, look, I'm more than willing, I've got a duty to present that to my client, but in addition, I'll even back up a little bit because I don't want to force her into something that could lead to basically a trial tax.
Yeah.
I want to make sure that it's not me pushing her into this trial. And we did end up working it out. Ended up being a pretty good deal for her, and we did not go to trial. I would really have liked to go to trial, but it was my client's choice, and she decided to take 9 months and a $250 fine on a DWI charge that was over 0.15.
Yeah.
So
Get the enhanced.
I'm kind of dovetailing on what you said. I think one of the other big factors is bond. If the client's on bond, at least in my practice, their number one concern is not going back to jail at all costs.
Absolutely.
Not going to happen, and they're just not going to take it. And so, at least on some of the misdemeanor side, if we push and keep pushing for a jury trial, ultimately it ends in a plea that we want. Usually, and in the top cream, we end up going to the jury trial, and we end up having that trial. But I think the big factor is bond. If you're on bond and you don't want to ever go back to jail, you have the ability to play the game, the waiting game that the state loves to play when that individual's in jail. And when you get out on bond, you can neutralize that and you can attack at a different level.
True. I want to get back to this conversation, but we got a phone call coming in I want to get to. So let's drop that in here. Hello. Thanks for calling Reasonable Doubt.
I can't understand. I want you to unpack this for me a little bit, Jimmy. Isn't there supposed to be a separation of powers within the legal system of the sheriff, the city police, the DA? They have a working relationship. They see each other every day, but the sheriff or the city police are not the client of the DA, and I don't understand how you can affix a sort of immunity to and that's how I see it, that exists against your client and against everybody within the criminal justice system that's facing the machine. Can you respond to that?
And you're talking about this in relation to what happened in Waco, correct?
Well, I'm talking about a Brady notice and essentially how cops can be protected by a DA that doesn't see justice in the same light that people in the defense bar do.
Yeah, no, it's a very valid point. I mean, that's what I want to make clear. I mean, I think the discussion about whether or not they're turning over bad cops and turning over the information on them, I think they're probably on a solid legal ground to do it. Do I think it's right? No. I mean, I think that, as the caller points out, that they're there to do justice, and isn't part of seeking justice outing bad cops. I mean, we have a public integrity division. They should at least know about this stuff. So I mean, I agree with you. I mean, it's a problem, but also in the sense, I mean, I think that legally they have a very sound legal argument for trying to say you can't use this but for purposes of the existing litigation. But I totally agree with you. There should be there should be a duty on their part to bring the information out.
I think. Okay. Continue, caller.
Yeah.
Go ahead. I'm listening.
Well, kind of developing your separation of powers. So often we see or we feel like the prosecution and the judge are on the same on the same side, when that shouldn't be the case at all. It should never be where it's the defense versus the prosecution and the judge, or the judge, or so to say, the judge and the state versus the defense. Do you see that, Brad, or do you feel that there might be some separation of powers issues, or what are your thoughts on that?
Well, I mean, most of the judges that we've got in Harris County are former prosecutors. That doesn't mean that all of them haven't been able to get to a point where they can be fair, but I think that a lot of them are prosecution leaning. No question about it. And any time I've ever brought anything against the basis being that the cop did something wrong in the case, there's definitely a bias there toward supporting that cop. And he can have a very fishy story, and unless you've got them just dead solid on camera doing something red-handed, it's not enough. That judge, 99 times out of 100, is not going to find that officer's story not credible, even if the story is very not credible.
Well, and you guys talk about separation of powers, excuse me, and judges and DAs kind of being aligned. This article over the weekend about diminishing jury trials in federal court, what really is your trial tax, and where the separation of powers comes in is that Congress has set forth all these mandatory minimums. They've basically given the power to the prosecutors to charge these things and handcuff the judges. So if you go to trial, you might rise from a 10-year mandatory minimum to a 20-year mandatory minimum if you go to trial and lose. Or you might get charges stacked because it's mandatory based on Congress. And again, the judge's hands are tied. They can't do anything but sentence you to 150 years because that's what the statute calls for. So in that regard, that is what has been the trial tax. But it got me thinking, kind of along your lines, about what happens in state court and what we were talking about before, the trial tax that we all know about in state court that happens in a number of different courts, in a number of different cases. And my problem is that when the DA makes you an offer and you go to set the case for trial, they tell the court what the offer was, and the court wants to know what the offer was. I don't think the court should know. I don't think that's proper. I mean, the judge is supposed to be neutral and supposed to call balls and strikes. What business is it of theirs to know what the offer was? What business is it?
Mm-hmm. And on the same token, we have, it happens all the time in the state court where we go up to the judge and what are they offering? Oh, well, I'll offer this. Y'all should go back and talk. And it is, I think it is a separation of powers issue fundamentally where that judge is intervening. Now, I'll be the first one to say, though, and sometimes I want that judge to come in. I'll be the first one to say it.
I hear you. It's a double-edged sword because sometimes a certain judge, a good judge, can force the prosecutor to give you a better deal, so to speak. Kind of like, hey, I wouldn't do that if they came to me, kind of deal. I don't know what you're thinking on this. So it's a double-edged sword. But my point is that when you get to trial time and you're setting the case for trial and you're not bringing an agreement to the court for the court to approve, I'm not really sure what business of it is for the court to know. Because if you elect judge punishment, if you elect for the court to punish you rather than the jury, well, the judge has now been poisoned by what the offer was.
They got some sort of reference in their head and such, yeah.
They know what the state thought the case was worth pre-trial.
Honestly, I think most judges want to know that, not so much for actually deciding what they would do, as much as trying to force the case not to go to trial.
Sure.
They want to control their docket and they want to try to streamline things, and I think that's what they're trying to do. I don't know if that makes it any more proper, but I don't think it's necessarily so much to decide how they're going to rule on the case as much as can I dispose of this case without sitting through a trial.
No, it's true.
I think you're spot on, man.
Yeah.
I think you're spot on. I think so much of it is docket control. And I was thinking about it today in court, sitting in court, bouncing from court to court, waiting on judges, waiting on things, and getting disrupted with trial. I just think there needs to be another, I don't know if more courts are the answer or if, when they need to have associate judges like they do in other counties, So they need more like project courts where we can have trials, where we can have them and justice can be administered without haste, without prejudice, and individuals can just say, you know what, I want a jury trial. If I lose, I lose. If I win, we win. And we can have this trial without the judge intervening with the docket. And I don't know what the solution. Maybe we need like 15 more courts. I don't know.
Well, you know, in federal court, they use the magistrates to take pleas, to handle a lot of ancillary matters. They will use the magistrate judges for that. Over at the state level, you know, in family court, they have associate judges to conduct hearings. They do evidentiary hearings, all sorts of things the associate judges do. I don't know if there's a way to craft some sort of associate judge plan or use the existing magistrates that you have to take the load off. I know they've done stuff with, you know, what is it called? Impact court, state jail court, the drug court, or whatever it is that they send all the state jail drug cases to. Are those the only two?
Well, they had a misdemeanor impact court, and that turned into 16, and they still have the 20th floor on the felony side. I think that might be. I don't know where they're going to put them. I mean, we're running out of courtrooms. You know, maybe they need to build a new court building. I don't know, a new courthouse.
Yeah, I don't know. I mean, I don't think that this article is the woe is me, woe goes the jury trial. Lawyers aren't going to get jury trial experience, which we've seen that movie play out on the civil side now, where there just aren't a whole lot of civil trials anymore. But I do think if you go over across the street to 201 Caroline, there are becoming more and more civil trials every day. You talk to the judges over there, more and more civil cases are getting tried. So maybe there's a renaissance of this stuff. I mean, I don't think it's going away in criminal cases. I think criminal defendants are always going to thankfully exercise their right to a jury trial, because frankly, it's the last check we have on the system, so to speak, where hopefully the facts come out, so to speak.
Well, and if you haven't read the blog this week about representing those people.
I was going to get to that, Brian Roberts did a very, very good article on the question that we all get. How do you represent those people? And we get it every single time.
Brad, what made you decide to do criminal defense?
Honestly, it was happenstance. I was originally, when I first got out of law school, I was doing civil work, just wage and hour cases with a big retailer, going through their hard drives and figuring out what the other side got to see. When some of that work started winding down, I had a friend call me. While I was on the job, doing that job, a friend called me and said, I just got a DWI. And I said, man, I've never been in a courtroom. I can't help you with this, but I work with a lot of people that do criminal law. I could get you hooked up with somebody really good. And I said, let me try to do that. And he said, okay. And so I talked to the guy that was sitting right next to me on this project, and he had done murder trials. And he said, you need to take the case. He said, I'll talk you through it. And so while I was still in that realm, I worked my first DWI case. We went all the way through, set it for trial, and they dismissed it on day of trial.
Nice.
And this guy talked me through the whole thing, gave me some of Trichter and Murphy's instructional booklets and stuff. And I said, I enjoyed this. And so when that work wound down, I just decided to start doing criminal law.
Well, Brad, you've been a very good voice for the defense bar, a champion of individual rights. What do you think is what motivates you to continue to be in this line of work?
What really motivates me is making the system work better. And I think that I just can't believe the percentage of my cases where I find an issue with how a search was done, or was the stop legal? Such a large percentage. There's actual huge problems there, and I enjoy pointing that out and making sure that judges and prosecutors are aware of it, and seeing how I can work that to my advantage. I mean, honestly, only a small percentage of my clients are actually innocent, but the system is so bad. The institution is just so overrun with people who will just either don't know the law or know the law and just disregard it with just flagrantly.
Do you think?
Oh no, I was just going to say, share a anecdotal story.
Yeah.
Story time. No, in law school, I had a professor who was a criminal defense. He practiced criminal defense, and he taught criminal law. And it was our first year of law school. And one of the girls in the class goes, real indignantly, goes, "Ugh, I could not do what you do." And to which he looked at her and quickly and tersely responded, "Well, I bet there's a lot of things you just can't do." I mean, and that, you know,
Like get an A in my class.
yeah, and to me it was kind of like that was kind of the first for me that was like, yeah, I kind of like this attitude, you know? I mean, I want to see what this criminal law thing's all about. It's kind of like people do kind of view you as, you know, like, I'm not sure I want to be a part of that. But you know, like Brian says in an article, you go anywhere to a cocktail party or a night out at dinner, and people want to hear your stories. They sure want to hear your stories over everybody else's.
This one time I went to one of these, I guess it was a civil kind of cocktail party, sit down kind of deal. And I was the only criminal defense lawyer there. And they said, what's your, talk to me about your craziest case. And I thought they were serious. And I said, well, I got this one case where they chopped off the head, and then before that they mutilated the body, and then after that they burned it and then did all kinds of things to it, and it was just awesome. And then
And there's nothing but crickets.
I realized that, and I looked around, and everybody was just. And I said, "Oh no!
I'm just joking with you."
No, this guy, he walked into a bar and he, got drunk, and yeah, it was the most awkward situation. It was one of the first times I realized that, other individuals think we represent those people, when in reality, if the way we treat the least among us is how we should judge the society, and the way we defend those individuals accused of crimes affects all of us. And so if we don't defend and hold the police to task on everything and anything that we can that's within the constitutional bounds and ethical bounds of what we do, everybody's at risk. And everybody could suffer.
I was talking though about this with another friend of mine who used to be at the Federal Public Defender's Office. Now is out on his own. And I mean, the hard part is when you listen to your friends or your family, and they talk about what a hard day they've had, or they're griping about some problem they've had, and you aren't as sympathetic to their plight, I find, because you're like, really? You're whining about that? Let me tell you about some problems. Let me tell you about what this person's going through in their life, and let's just reevaluate here. So from that, I think doing this also, it kind of warps your perspective a little bit, because you're unable to sometimes relate to even those people closest around you when they have problems going on, because we live in a world where the problems we deal with on a day in and day out basis are of the greatest crisis for the people that we represent. And so it makes everything else that comes into your life, short of, a loved one going through a major medical trauma, almost inconsequential. And you kind of just like, it's no big deal kind of thing.
The worst thing, one of the things, so my wife's pregnant, and my son just broke his leg, and I have another son who's 4, and I told my wife, and we're looking at each other, and she's, how am I going to do it? And I'm coming off one of these days where I'm just I'm in the foxhole, I'm in the trench in the courthouse. My wife's telling me this, and And I just tell her, well, you're just going to have to suck it up. Oh, it was horrible. It was bad. Don't ever do that. But it goes back to what you're saying, like, you know, these individuals, they come to us and we have to step back and say, these people are dealing with things, and just because we're interacting with them all, it doesn't mean that, these other life circumstances are any less important.
Right.
But Brett, what do you think is the most difficult thing or the most trying thing about being a defense lawyer?
Worrying about what's going to happen to my clients if I'm not effective. You get people that are, I've got clients right now, they could be gone for the rest of their lives. And I have a tendency to internalize what they're going through and put myself in their shoes. And I don't know, it might be a lot easier to do this job if you're a sociopath, but it makes it really hard to do the job when you have feelings for what's happening to these people.
Let me follow that up with and ask you, what do you think is one of the most pressing issues that is facing individuals who are confronted against the justice system?
I think the thing that scares the bejesus out of me is people prosecutors that won't turn everything over that they're supposed to, and you see so many cases like with what Casey Otro has uncovered, and those 36 items that hopefully they're going to get a new trial on that case, but that's an institutional problem, and it's still going on, and they're still fighting giving you stuff that they know they have to give you, and I'm so afraid that I'm going to be one of those attorneys that my client goes away for a long time, and it's because they didn't give me what they were supposed to give me, and I wasn't sharp enough. If Dick DeGuerin couldn't get it from him, I don't put myself in his league, and if he couldn't get it from him, and here we are 10 years later still dealing with this to get this guy out. That puts a lot of pressure on me, knowing that better people have been undone by these guys basically cheating the system.
That's the hard part. I don't think people realize. They look at lawyers and they say they're just out to take our money, and there are some lawyers like that, but they don't realize that the overwhelming majority of the lawyers that do this day in and day out, they dump their heart and soul into this, and they do go home and they internalize and they have sleepless nights thinking about what they can do to help their clients. And if you didn't get a chance to read the article by Brian Roberts, who has been on this show before a couple times, great guest, we're going to need to get him back on the show, go check it out. Check out our website, www.hcclatv.com. We got that and a lot of great other blog posts there for you to check out. But that's all the time we have for tonight, ladies and gentlemen. I'd like to thank our guest, Brad Walters, for joining us. Brad,
very welcome.
It was great to finally meet you and have you on the show.
Thanks for having me. I enjoyed it.
Absolutely. Julio?
I am so happy that you're finally on the show. You've been thank you for coming on, man.
I appreciate you inviting me.
Till next week, my friend. We will see everybody next Thursday night, same time, same channel. Good night.